Namaskar. Welcome to another episode of Dialogue. We have been talking about courts, we've been talking about judges, we've been talking about justice. And lot of questions we've raised, lot of point of views we have presented to you. And incidentally, I came across this brilliant book, Incomplete Justice, the Supreme Court at 75. And it is compiled by S Muralidhar. Justice S Muralidhar is a very respected judge, former Chief Justice of Odisha. And if you remember, I had done a show, I had done an editorial on his, when he was transferred out of Delhi because possibly he asked questions that made the government uncomfortable. So, yeah, Justice Muralidhar has compiled this book. This book actually talks about a lot of facets of law, different subjects. And today, I've got three guests. Justice Muralidhar is with us, and Gautam Bhatia, lawyer, is with us. He has written about press freedom. Suhith Parthasarthy, also lawyer, is with us. He wrote about the 10th schedule. Let's talk to these gentlemen. Let's understand from them as to how does our law actually work? How do they feel sitting inside the system? How do they see the system? And let us understand a little more. Let's get right into the show and talk to these illustrious gentlemen. What motivated you to compile this book? Was it the post-retirement activism?
The idea was to get a volume of introspective, reflective pieces that tell us about the working of the institution. So it's an uneven track record. You can't say that everything that the court has done is right or everything it's done is bad, or it's always remained on a certain trajectory. Some of it has been disappointing and some of it has been restoring hope.
Anti-defection laws have failed. Why do you say that?
What it does is that it gives the Speaker of the House the final authority to decide on disqualification. And this introduces an element of partisanship.
You see, the Supreme Court, after all, is the Supreme Court of India. And when it is saying something about a governor's conduct and the ruling dispensation finds no problem at all, will allow the governor to continue or just shift the governor to some other state as well, then what is the regard that we are having to the view of 5 judges of the Supreme Court?
Possibly at times the judge is more relevant than the petitioner and the accused. You see, because end of the day, one can actually predict the decision based on who the judge is.
And so if the Chief Justice wants to ensure that, for example, in a Kappan kind of case, then it will go to a judge who is not very sympathetic to considerations of liberty. And the Goswami case will go to a judge who is more attuned to these considerations.
The bar, I think, steadily has lost its independence. I would say that because the manner in which elections are conducted to the bar councils and bar associations and how some forces have captured the majority voice of the bar, that needs course correction immediately. Because ultimately, judges come from among the lawyers. And if we don't have independent lawyers, we cannot have independent judges.
Thank you so much for joining me, gentlemen. Justice Muralidhar, Mr. Parthasarthy, Mr. Bhatia, thank you so much for joining. And today we're discussing your lovely book. I went through it actually, most of it, and quite interesting. Sir, I would like to start with you, Justice.
Yes.
What prompted you? What motivated you to compile this book? Was it the post-retirement activism, as a lot of people say, or was it...
No, you see, we do have commemorative volumes come out when the institution completes, let's say, 50 years and 75 and 100 and all of that. And I was anticipating that there'll be an official court publication like there was when 50 years were completed. The experience we have is many of these volumes brought out by the institution itself are not really critically reflective of what the institution has been through. And I thought it might be a good idea to bring together scholars not just lawyers, but even academics. And we could persuade one very veteran senior journalist, Mr. Sainath, also to contribute. So the idea was to get a volume of introspective, reflective pieces that tell us about the working of the institution.
Sir, incomplete justice. Now, it's a very interesting line. Incomplete justice. What prompted you to go with this particular?
Because this phrase "complete justice" forms part of Article 142 of the Constitution, and many of your major decisions that the court has handed down over 75 years, some of them it is actually drawn on its powers under Article 142 to say that we are doing this in the interest of complete justice. And very often those could actually generate even more confusion or problems, leaving that whole exercise far from complete. That's one explanation I have. The other is that our respective viewpoints that we have, the subjective viewpoints that we have, whether as people engaging with the institution as lawyers and litigants, or even institution watchers, we could have different perspectives on what the court is doing overall and in particular cases. And there is a sense that some of us have that, something is half done, unfinished, and it is only to generate a debate. See, we are not writing these pieces in this book expecting that a reader has to necessarily agree with each of us. We are fully conscious that what we are putting out there is meant to generate debate and discussion. So the question mark also indicates that we want to, have that active and animated discussion amongst all of us and even people who may not be lawyers and judges.
I want to ask you one more question in this regard. Sir, your journey, late 80s as a lawyer to a judge, and of course, a lot of things happened. How would you rate it, sir?
No, it's been, a life in law is never dull. And if you're passionate about it, you can see, the scope that one has to make a difference in whatever little way. But the most important thing is there are millions of people waiting for justice. And we're never going to have enough lawyers and enough judges to deal with all these issues in the manner it should be dealt with. So this is also a book of hope, just like my whole career has been one of hope. And these two young, bright legal scholars and lawyers themselves will also probably share that viewpoint. We are not expecting ourselves to give up what we are doing, irrespective of whatever challenges we may face in navigating, through that maze, legal maze, as we call it. Most importantly, we are helping people navigate the system. And people are waiting with great hope. So it's all the more an added responsibility on each of us to make every bit of an effort we have to make sure that people reach that goal of justice. We may not succeed always, but on those moments when we succeed, it's extremely satisfying. And I can say this, whether as a lawyer or as a judge, and now again back as a lawyer, we don't know when those moments arise, but when they do, it gives one a lot of satisfaction and hope. So this is really a book of hope.
Is a judge treated justly in the legal justice system?
See, it's hard to generalize anything like this and to give yes or no answer to this. It'll all depend on the context. There will be moments when we feel a judge has not been treated fairly. And I think we're justified in those kind of comments. Like, for instance, what happened when the supersession happened in 1973 and again in 1976. So there are those moments when we feel that judges have not been treated well enough. And perhaps even now we could feel about some of them. But it's difficult to give a general, broad answer saying yes or no.
Mr. Parthasarthy, you say that anti-defection laws have failed. Why do you say that?
Yeah, look, obviously the anti-defection law, which was introduced through the 52nd Constitutional Amendment way back in 1985, it was meant to curb a very particular menace, right, of legislators switching sides either for power or money. And you had the problem of Ayaram, Gayaram, etc., which most people were aware of. But the law, I think, at any rate, and its design, is sort of intrinsically flawed. what it does is that it gives the Speaker of the House the final authority to decide on disqualification. And as we know, the Speaker of the House invariably belongs to one party or the other. And this introduces an element of partisanship in the debate. And in its very design, therefore, the law leaves much to be desired. Now, originally, when the constitutional amendment was made, judicial review of these decisions was also altogether barred. But thereafter, the Supreme Court in Quixote Holohan's case in 1992, it upheld the law, but it allowed for limited judicial oversight. So what my chapter in the book seeks to do is to sort of unmask some of the inherent flaws in the law and really sort of try and bring out how this concept of mergers and splits, etc., which has now been written into the Constitution, is more a tool for political engineering rather than it really acting as a true deterrent to the kind of defection that the law was meant to curb. And what the law has also done is, through the merger loophole, it's allowed and legitimized mass defections on the one hand. The biases of the speaker has sort of been enabled. And the Supreme Court, although it enjoys this power of limited judicial review, what it has done really, often through interim orders, it's effectively become a political player in its own right. And examples abound. You've had examples from Goa, Uttar Pradesh, Manipur, Karnataka, Madhya Pradesh, all of which is discussed in the chapter itself. So, and also what the law does, therefore, as a result, is that it fails to act as a deterrent and as the kind of democratic safeguard that it is meant to act as. And the deeper problem, of course, is also that India's parties themselves lack internal democracy, right? So, and I think no anti-defection law can really cure that. But it also means that the party whip enjoys a kind of untrammeled power, which means that there can be no internal dissent. You can't have a legislator taking a view distinct from what other legislators from the same party might take. And this really diminishes our parliamentary democracy in many ways.
While reading your chapter, I was a little confused as a layman. So you were talking more of the court not able to implement the anti-defection law more than the anti-defection law itself being flawed.
No, I think it's a bit of both, right? I mean, the focus in the book is obviously on the court because we are talking about the Supreme Court in 75 years of the Supreme Court. There are clearly flaws in the 10th schedule itself and its design. But the Supreme Court correctly or incorrectly upheld the law. And having done so, I think it's had very many opportunities to kind of shape the law in such a manner that would enable democracy, that would ensure that the law's true objectives and purposes are met. But that's something that perhaps on some occasions it's failed to do. And on those occasions, and which are the occasions that I've pointed to in the book, and I mentioned Madhya Pradesh, Uttar Pradesh in the past, Goa, I've taken examples from Karnataka, which really go to show that the court has fallen short. And in doing so, it's also wound up effectively acting as a political actor rather than as a disinterested judicial actor.
Yes, I just wanted to add one thing. See, one thing that we don't find actually acknowledged by the Supreme Court, and this is a big flaw in the provision itself, is the power of money. You see how corruption has crept in a very, very big way, because the law is designed to cater to defections of a few, not en masse defections. So what we are seeing of late is en masse defections. And it's all getting played out in front of the court. You know, when you have a plane load of MLAs taken off to a resort, kept there so that, they're insulated from their own party people. So these kinds of things are not a one-off experience. It's happening on a regular basis in each of the cases that Suhith talked about. And which is what I think he's also trying to point out through that essay, that the decisions that the court takes in individual cases has to account for this element of corruption, which is completely distorting what a popular mandate is all about. Suhith, I don't know if you want to react to that.
No, I think, you've sort of said precisely what the chapter was meant to do, and that's what readers will take away from that as well.
Mr. Bhatia, I want to get you in here. There's this cliche that it's whether does the court dispense justice or does the judge? How factually correct this statement is under the current circumstances?
Yeah, I think like that's a very complicated question, which would take a very long time to give a full answer to. I think one interesting thing I once read was someone said that in a really well-functioning society, you will not know the name of your Chief Justice as an ordinary person. You will not know who is on the Supreme Court because you wouldn't need to know. Now, that's not the case in India, and that's not the case in the US. It may be the case in countries like South Africa and so on. But it is basically, in some ways, the fact that you know exactly who the Chief Justice of India is and their entire history is actually a sign of a dysfunctional system, because you shouldn't be knowing that. You shouldn't have a need to know that. Now, I think that one thing that, again, I think is a part of the pathology of the Indian legal system is that judges are obviously human beings, and like every other human being, they don't. It's not that they check in their ideology out of the door when they enter the courtroom. They carry that with them on the bench. The point is that the legal system is meant to create certain kinds of institutional, checks and balances that minimize the effect of ideology. So, for example, following precedent, certain clearly defined approaches to interpreting a text, the difference between creating new meaning and just interpreting a text. There are all these forces that are meant to, in a certain way, keep the individual judicial ideology in a certain kind of check. I think one of the issues that we are seeing of late is a dilution and a weakening of those kinds of checks. So we see, for example, the gravitational force of precedent has been diluted a lot in the Supreme Court, where you have openly benches not following precedent, ignoring it, or just declaring it to be non-binding on them and so on. That's one thing. And I think secondly, we just so I'll give you an example. Like my piece in the book is on media freedom. Now, when you look at the issue of when a court should grant a pre-trial injunction, if a person complains that a defamatory thing has been said, it is the law on that is very, very clear that if the defendant, that is the person accused of making a defamatory statement, claims that he or she has a defense and that he or she will prove that defense at the trial, unless that defense is very clearly absurd, the judge is not meant to grant an injunction. Your idea is that then you go to trial, and if defense fails, then you have damages. That's the way it goes. That is very clearly what the law is, except that from the Supreme Court down to the trial court, no one follows it. If they want to, they'll follow it. If they don't want to, they don't follow it. So I think the problem is that while accepting that judges as human beings will have views, ideologies, attitudes, and approaches, a well-functioning legal system is meant to acknowledge them while also mitigating their effect in an individual case. And that is what is weakening in India right now.
When we see here, talk about cases, the judge on that case is so relevant. Possibly at times the judge is more relevant than the petitioner and the accused. Sir, isn't that true?
No, you've hit the nail on the head. As practitioners at all levels of the courts, when we realize that the case is going to be taken up by a particular bench, a combination of judges, our strategies in fact change. See, this ties in with what Gautam is saying, that ultimately the judge is a human being and you have to connect with the mind of the judge. So you should know what are the predilections of the judge. A judge may have strong positions which the judge has expressed through orders and judgments. So having studied that, you know where the judge stands on certain issues, what is the attitude of the judge to certain kinds of cases that come. So as lawyers, having to strategize in a litigation, we do take into account, and our litigants themselves who watch the court are able to tell us, listen, this kind of a judge. So we have what we call, when we say that, you're going to have a tough time in this case before this judge. And this happens at all levels of the judiciary, so it's nothing unusual. But what I wanted to add to what Gautam was trying to say is that there is something different about our Indian Supreme Court than other Supreme Courts in the world. See, we have 34 judges who sit in as many as 14, 15, sometimes 16 benches. And, those benches could be of 2 judges or 3 judges. And it's very likely that the reaction or the approach of one bench of 2 judges could be sometimes diametrically opposite to the reaction and approach of another bench of 2 judges. So this also adds to the complexity of the whole functioning of the judicial system. Second point I wanted to make was not just about following precedents, even doubting your own precedents. You see what is happening, and I can give you 2 examples. 5 judges sat down to decide an issue whether an agreement which specifies that the dispute will be resolved through arbitration, should it be stamped even before an arbitrator is appointed? This was the issue. 5 judges decided in a certain way. Within a period of 2 months, it was already before a larger bench of 7 judges. Now, this is not allowing a 5-judge ruling to even survive for a couple of months or 3 months. Likewise, in the Shabarimala case, which you, I'm sure, Mr. Nair, are aware of, 5 judges decide the case on a 4:1 majority. Within a few months, not only a review is allowed, but the whole matter has gone to a larger bench of 7. So this is a phenomenon, again, that we are finding, which answers your first question, that judges in the court, individual judges, are determining the course of litigation. Whereas, as Gautam said, an ideal situation is where we don't know our judges and we say, okay, this is the voice of the Supreme Court, and we respect that.
Does a judge follow the law, or does a judge follow his or her ideology in real world?
No, Mr. Nair, actually, in the real world, just imagine a general hospital, okay? There are so many emergency cases coming in. There are routine cases, right? Like every day in a hospital, government hospital, let's say 50 babies are born. So in the gynecology ward, there'll be a certain routines followed, right? Likewise, in every court at all levels, there will be some routine run-of-the-mill matters. And many of the judges are doing many of these run-of-the-mill matters, even at the level of the Supreme Court. Now, the cases that test one's ideology are not as many as you would imagine, because those grab the headlines and we're invariably discussing those cases. So on a routine basis, even in the Supreme Court, let's say on a Monday, every bench of 2 judges is dealing with, let's say, 60, 65 cases. Now, all those cases will not test the ideology of the judge. So we should put this in perspective. There are some cases in which that ideology gets tested, where the judge's inherent biases get reflected. But as lawyers, as legal scholars, we know where that comes from, and we learn to analyze it the way it should be analyzed. I don't know if I've answered your question.
And as a citizen of this country, I have to first pray that I get a good judge who will be fair with me. And secondly, I have to pray that, my case doesn't fall into any ideological issues, so that, I don't test the judge's ideology. Mr. Parthasarthy, I want to get back to your chapter, wherein you've spoken about Shiv Sena. And what is your opinion about the case? What's your take on the case? And do you think justice was delivered?
Well, look, I've analyzed it in the chapter, and I've also sort of pointed to the case as an example for why the 10th schedule hasn't worked out, and why the manner in which the courts have dealt with issues arising under the 10th schedule have left quite a bit to be desired. We're all sort of broadly aware of the facts leading up to the judgment itself. After the 2019 elections, we know that the Shiv Sena formed government in alliance with the NCP and the Congress. And Mr. Uddhav Thackeray was chief minister. And for some period of time, the government and the coalition held steady. And then sometime in June of 22, I think, came the sort of rift. And there was a faction within the Shiv Sena. About 40 out of the 45 MLAs broke away. And they claimed that they were the real Shiv Sena, led by Mr. Eknath Shinde. And sort of almost overnight, you had this constitutional and political storm that brewed. And even though there were directions that were issued by the party whip, who belonged to Mr. Thackeray's camp. The rebel MLAs did not attend those meetings and support the government. They ignored those directions. And you had the Shinde faction run to the Supreme Court. And you had a series of judicial interventions that followed, which effectively decided who would rule Maharashtra. And I think the court's first move in this case was to extend the time that was given to the rebel MLAs to reply to the disqualification notices that were issued by the deputy speaker. But this was, on the face of it, it's just a small procedural step, but it bought them some amount of time. And then the very next day, you had the governor of the state citing a loss of majority and ordering a floor test. And on this occasion, you had Thackeray's camp going up to the Supreme Court asking for a stay of the test, effectively arguing that the disqualification proceedings had to be decided first. But the court refused. It said, let the floor test happen. And faced with that, Mr. Thackeray resigned, and we all know how things went about later. Thereafter, of course, the matter once again reached the Supreme Court. And this time it was tested against the anvil of the 10th schedule. So the court had to effectively decide whether the speaker could have acted when there was a motion pending for his removal, and whether the governor could have at all called for a floor test based on just sort of political letters rather than any real clear idea that the majority had been lost. Ultimately, the judgment, when it came about, what it said was that the governor's decision was wrong, right, to call for the floor test. And that was the decision on the merits of the issue itself, that he had no objective material to call for the floor test beyond a few letters from some MLAs. And I think here is the irony, really. The court said that it couldn't undo what had already happened. Because Mr. Thackeray had resigned voluntarily, it couldn't restore the status quo, it couldn't restore the old government. So we ended up with this peculiar situation where the court agreed that the governor had acted illegally, but that government that was formed as a result of that illegal act could continue to stay in power. And I think this sort of highlights why a fait accompli is often created when the court fails to act on an urgent basis, fails to grant interim relief in the manner in which it must, and really fails to hear and dispose of some of these big constitutional cases as expeditiously as possible. And we've seen these fait accomplis being created in very many different cases. It's not something that's peculiar to this case. We've seen it in the case of Aadhaar, we've seen it in the case of the demonetization issue, and so many other big constitutional cases that have come up before the court, but where the court has sort of really deterred and not acted with the kind of promptitude with which it must act. And that's something that's not something that's peculiar to the court's actions in the last 10 years or last 15 years. This is a criticism that can go back in time, really. And it's something that I think the book sort of seeks to bring out, not just in the context of the Shiv Sena case, but in the context of very many other issues as well.
In Shiv Sena's case especially, we literally saw Supreme Court pleading to the Speaker of Maharashtra, pleading so that he kindly conducts whatever inquiry he has to, kindly give the report. He was given a date. Then he said, no, I don't want to do it at that part in time. I may want to take another 10 days. Then he was asked, please give me another. So is this how it works?
No, it doesn't. I must tell you, if you want to read Suhith's chapter, there are earlier instances and probably even later instances where the court is fully conscious what it is doing, either by postponing a date or by advancing a date. Sometimes in the same case as in the Shiv Sena case, it's fully conscious how the whole thing is going to play out. And Sujit, I just wanted to remind all the viewers of your program, when we talk of the court, we seem to think that the court is simply sitting as a chamber with no one doing anything in front of it, and somehow the judges are simply deciding. The lawyers play a major role. The lawyers play a very, very significant role in cases like this, what they project, how they project, and what they tell the court. So it's not as if we should view this only as the court itself or somehow doing it. It's accepting or rejecting some lawyer's plea on these issues. But I think Suhith's point is very critical in one more aspect. see the conduct of the governor. Governors are supposed to be non-partisan. I mean, that's the expectation in the constitution. But the 10th schedule, and it's not just about the present dispensation, the 10th schedule, the way it has operated, whether earlier, during the earlier dispensation and the present dispensation, has exposed the governor's partisanship. And they're all acting as an extended arm of the party in power. And this should lead us to reflect on whether these kind of offices need to be questioned more sharply. We are, despite all these comments and the ruling of the Supreme Court in the Shiv Sena case about the role of the governor, nothing happened to the governor. The governor is not even saying a sorry. He's not even saying sorry. So I'm just saying that it also brings down, you see, the Supreme Court, after all, is the Supreme Court of India. And when it is saying something about a governor's conduct and the ruling dispensation finds no problem at all, we'll allow the governor to continue or just shift the governor to some other state as well, then what is the regard that we are having to the view of 5 judges of a Supreme Court? This is something that we need to ask.
Let me ask you a very honest question, Mr. Bhatia. Do you think there is media freedom? There is press freedom in India? I will not. This question is not to a lawyer. This question is not to a lawyer. It's to a layman, and then we will talk to a lawyer.
Yeah, no, I think it depends on the sense in which you understand the word freedom. So if the freedom means that freedom from coercion and various coercive actions taken by the state or state agencies, then there is one answer that you can give. If the question is freedom from the kinds of economic dependencies that would allow the media to be independent of corporate funding or corporate structure, then it's a different answer. Right? So in both cases, the answer is it's not really very free right now. But the nature of the answer would change depending on what you understand as freedom. So as I say in the chapter, you have a sort of very patchy record over the years when it comes to censorship and the restrictions placed on the media by the state. One example I gave right now was on pre-trial injunctions that the court has been too free to give across the country. We saw that most recently in the whole Adani case that was going on. Other things, blasphemy laws, contempt of court, criminal defamation, other provisions of the law, those issues. And I think the other thing is what I've said is that the Supreme Court has really been has not paid attention to the interface of economic structures, ownership patterns of the media and freedom. So how free is a media that is effectively controlled and owned by certain corporations, certain very wealthy individuals? To what extent does our law and our jurisprudence require a diversification of control over the media? All these are questions that really impact the state of media freedom in the country.
Cases like Kappan versus Arnab Goswami, you see, almost the same story, but seen through different lenses, given two different treatment.
Well, there, unfortunately, you come back to your first question about judges, right? So, and in fact, there the issue is more the behavior of the Chief Justice of India, whoever it is occupying that office, because the Chief Justice basically decides whom to assign cases to. And so if the Chief Justice wants to ensure that, for example, in a Kappan kind of case, then it will go to a judge who is not very sympathetic to considerations of liberty. And the Goswami case will go to a judge who is more attuned to these considerations. So that's the function of the arbitrariness of the Supreme Court and just the kind of unaccountable power that the Chief Justice of India has to really influence the outcomes of cases through the process of assigning cases to any of the 34 judges or 17 benches of the court.
Sometimes, actually, during the hearing of a case also, we're able to sense which way the case can go as lawyers. So it's not just because it's before a judge, it's going to be that way. But Gautam is absolutely right when it comes to matters like bail and other things. We know the general drift of what the attitude or reaction of a judge or a couple of judges is going to be. So I think I would say partly yes. we would be able to anticipate what the result of the case might be if it's taken up by a certain bench.
Last three questions, 1 minute to each of you gentlemen. Sir, my first question is starting with you, Justice Muralidhar. 80s when you joined, late 80s when you came into the profession, and now has Indian judiciary deteriorated, or has it? Is it the same, or is it
No,
going?
it's been uneven. So the whole idea of the book is to tell you through 75 years. In fact, I've spoken in a whole section in the introduction about highs and lows. Right.
Yes.
So even as we speak, let's say in October of 2024, we had a remarkable judgment about caste practices in prisons. Right. It took the Supreme Court 75 years to identify it as an issue and to very strongly say it's illegal. And this is something that we would welcome. We would want a Supreme Court to call out these kind of practices. So it's an uneven track record. You can't say that everything that the court has done is right or everything it's done is bad, or it's always remained on a certain trajectory. What we're finding as legal scholars is that it's been an uneven track record. Some of it has been disappointing, and some of it has been, restoring hope. So I would ask the other two also to react to this question. It's an interesting question.
Have you been more disappointed with the judgments now, or have you been more disappointed with the judgment earlier on?
No. I'm more prepared to anticipate that we are going to have 17, 15, or 16 Supreme Courts, which will not speak in one voice, and lawyers now strategize for that also. How do you generate enough of momentum to quickly get a judgment referred to a larger bench for it to be overturned? So we've also geared ourselves accordingly. It's all not expected that in the Supreme Court, you'll have such quick overturning of judgments. But lawyers seem to know how to, even meet with this contingency. So it's very difficult to say, this is worse than what it was earlier and vice versa.
So, Mr. Bhatia, how do you see India, Supreme Court, in the next 75 years?
I mean, that's a really impossible question to answer. 75 years is a very long time, and it's really impossible to say where will we be 75 years from now, because you have many of the core issues of the day, like the climate crisis, just to take one. Will probably ensure that these questions will not even be questions we are worried about 75 years later. But I think, like, broadly, I can't say where we'll be, but I think what the hope is always that you have a court that is clear about its institutional role, which is to ensure that the power of the state, is wielded in a way that answers to certain fundamental principles of fairness, of justice, and of the protection of the basic human freedoms, and to understand that its main job is to ensure that power is channeled in that way. And anything else it does may be a bonus, may not be a bonus, but if it can't do its main job, then there's really, it's not really performing meant to do. So hopefully a judiciary that becomes aware of its role and at least attempts to perform it is, I think, the hope that one has going forward.
Mr. Parthasarthy, what do you think? The judiciary will do better than the legislature in the next 75 years?
Well, look, I mean, I don't think we should be viewing things in that manner, because ultimately it's a question of every wing of government performing its rightful role under the Constitution. There's separation of powers for a reason, and ensuring that that our Constitution's ideals are met. And in meeting those ideals, as Gautam said, the judiciary has a very clear mandate and a very clear role to act as a counter-majoritarian institution, where we live in sort of a culture of justification, where the state's authority is tested, and is tested on the anvil of the Constitution and its principles. And for that, it has to be independent. And in order to ensure an independent judiciary, there are many other things that we must sort of work towards. We'll have to think about how we appoint our judges, how we deal with misgivings within the sort of higher echelons of the judiciary in terms of corruption, in terms of other issues of integrity. And ultimately, we also need to ensure that those ideals of the Constitution, that is, ensuring that liberty, equality, and fraternity are fulfilled, that justice is for all, that everyone is treated equally. These are things that the court must use as a lodestar. And one really hopes, and the objective behind a book of this kind is to look at the past 75 years, look at the kind of mistakes that have been made, look at the things that the court has done correctly, and see how it can take it forward in the years to come. I don't think we should be looking at 75 years ahead, but look at the immediate future and see how some of these issues can be fixed.
Thank you so much, gentlemen. Thank you.
Yeah.
Please. You wanted to speak.
No. About the bar, I think I should have put in a word about the bar. The bar,
Please.
I think, steadily has lost its independence. I would say that, because the manner in which elections are conducted to the bar councils and bar associations, and how some forces have captured the majority voice of the bar, that needs course correction immediately. Because ultimately, judges come from among the lawyers. And if we don't have independent lawyers, we cannot have independent judges. So that is something we definitely need to work on. If you tell me what has really gone down over the years, it's the bar. But we're having a young crop of lawyers who are coming with a lot of idealism and who are doing very well in the courts. So my hope is that this young lot of lawyers who are better educated, better exposed, can make a difference and raise the standards of the bar the way it should, particularly before the top court, the Supreme Court of India.
Thank you so much, sir. Thank you so much for your time. And this was quite interesting read. Thank you so much for this book.